This is Bloomberg Law with June Grasso from Bloomberg Radio.
This week, the Supreme Court divided down ideological lines, gave the Trump administration the okay to resume quickly deporting migrants to countries other than their own, lifting a judge's order that gave them notice and a chance to argue that they would be at risk of torture. Over a scathing dissent from the court's three liberals, the court's conservatives granted an emergency request from the administration. Joining me is Elora Mukherjee, a professor at Columbia Law School who directs the school's Immigrants Rights Clinic. Elora, tell us about the judge's order that the Trump administration was appealing on an emergency basis.
A federal district court judge in Massachusetts was concerned that people would be deported to countries, third countries, where they would be tortured, where they would be persecuted, where they might die and be killed. And what the judge did is require that before non-citizens of the United States be deported to countries that are not their home countries, countries that they are not nationals of, that the U.S. government provides them an opportunity to contest and explain why they shouldn't be deported to that country. So that is called a credible fear interview process. And the judge held that people must get at least 15 days to challenge their deportations to countries where they fear torture and persecution.
Why are these non-citizens not being sent to their home countries? Why is the government trying to send them to third countries?
The Trump administration would like the ability, the power, the authorization to deport people to third countries when their home governments won't take them back. The men in these cases hail from various countries, including Myanmar, Laos, Vietnam, Cuba, and Mexico. And some of these governments actually do take back their own nationals. But the Trump administration would like sweeping authority to deport people basically to anywhere in the world.
The government made an emergency request to the Supreme Court. What did they argue?
The executive branch argued to the Supreme Court that the lower court order interfered with their ability to deport nationals to third countries. And the Supreme Court sided with the executive branch in that case and blocked the lower court order that required 15 days notice before individuals could be deported to countries other than their own.
So the six conservatives granted this without any opinion. Can we assume they bought the government's argument then?
I think that's a fair reading of the unreasoned order issued by the Supreme Court. It's worth noting that 3 justices dissented from the opinion and accused the conservative majority of, quote-unquote, rewarding lawlessness.
So Justice Sonia Sotomayor, who wrote that dissent, said that the administration had twice violated the court's orders in this case. The conservatives just ignored that, and does that send a message to the Trump administration that they can violate court orders?
Yes, this sends a message to the Trump administration that the Supreme Court is willing to turn a blind eye to the executive branch's flouting of federal court orders. Justice Sotomayor recognized in her opinion that the government had removed 6 people to South Sudan with less than 16 hours notice without any opportunity to contact their lawyers or be heard in court. And it is lawlessness. As Justice Sotomayor wrote, quote, "This is not the first time the court closes its eyes to noncompliance, nor, I fear, will it be the last," end quote.
Doesn't this conflict with the decision in April where the court said that the government has to give people a reasonable time to challenge their deportations?
The April case was in the context of a different set of laws. It was in the context of the president invoking the Alien Enemies Act. And in that case, the court held that individuals who were subject to the Alien Enemies Act needed to first be given notice that they would be subject to the Alien Enemies Act, and then a meaningful opportunity to file a habeas petition. But what that meaningful period of time is not resolved by the U.S. Supreme Court. That issue is currently being litigated in lower courts across the country, where the executive branch has invoked the Alien Enemies Act against Venezuelan nationals who are accused of being members of Tren de Aragua, a criminal gang.
The Trump administration returned to the Supreme Court yesterday in the case of those 8 men it wants to deport to South Sudan. So tell us what's happening there.
So after the Supreme Court issued its ruling on Monday, the federal district judge issued another order saying that a previous order in his case protected a group of men from being deported to South Sudan. The executive branch then filed a motion to clarify the court's June 23rd opinion on June 24th, and that motion has now been fully briefed as of today, June 25th, and we will see what the court does next.
Is it a problem because the court is issuing these rulings, this time without any opinion at all, on the emergency docket where they're not fully briefed, and so is it hard to interpret what they mean?
Yes, the Supreme Court's shadow docket has exploded in recent years and especially in recent months, and the Supreme Court is taking sweeping actions on the shadow docket that have just in the last 8 weeks deprived more than 800,000 non-citizens of their legal status in the United States. This current case that we're discussing now, DVD, is another example of the Supreme Court making extremely consequential decisions on the shadow docket without the benefit of full briefing and argument.
What does it mean on the ground? I mean, how many people might be affected by this order?
That's a really good question. The executive branch wants to implement third country deportations on a sweeping basis. It's one of the pillars of their effort to deport 1 million people from the United States this year. I think it's fair to expect that thousands of people could be subject to third country deportations under the Supreme Court's ruling on Monday.
This is a temporary order while the litigation continues. What's left of that litigation?
So to date, the judge has only issued preliminary injunctions. That is a form of temporary relief. The full case hasn't been presented to the court. There hasn't been a trial before the court yet. The judge doesn't have all the evidence needed in the case to issue a final decision. Typically, a federal district court will rule on all the evidence in the case and then issue a final injunction. Then the case would be heard by a federal court of appeals, and then the Supreme Court would take up the matter. It's a process of litigation that can easily take years. So it's extremely unusual that the Supreme Court intervened in this case at such an early stage.
In the government's filing, the Solicitor General assured the court that under the Convention Against Torture, the administration will not remove an alien to any country where he's likely to be tortured. Does that deserve any credence?
When it's coming from the same government that is trying to deport people to South Sudan with less than 16 hours notice, that claim seems meaningless.
Is there a question of whether what the Trump administration is doing violates the Convention Against Torture?
The U.S. government is a signatory to the Convention Against Torture. We as a nation will not deport people to countries where they are more likely than not to face torture. Deporting people to South Sudan with less than 16 hours notice raises a very high risk that the U.S. government is deporting people to a country where they will face torture.
Another escalation, the Trump administration has sued all the judges on the Maryland Federal Trial Court over a standing order that prevents the government from deporting a person for 2 business days after a habeas challenge is filed. 2 business days doesn't seem like a long time. What is the rush with all these cases?
The executive branch seeks to extend its power well beyond the system of checks and balances set up in the U.S. Constitution, and it is breaking our constitutional democracy. This is most evident in the immigration space and the lawless actions the executive branch is taking there, and it is exemplified by this case that is pending now in the District of Maryland, where the executive branch is suing federal judges for simply trying to afford them due process before individuals can be deported out of this country.
In the order from the Maryland court, it says that it's a response to an increase in habeas petitions filed outside of normal business hours from immigrants facing imminent deportation.
People, including children, are being picked up off the streets, at courthouses, outside of school, and being swept into a process that could very rapidly lead to their deportation. And federal habeas petitions are among the last bulwarks to protect people's due process rights and afford them an opportunity to prove why they should be allowed to stay in the United States, why it's unlawful to summarily deport them.
Thanks for joining me, Elora. That's Professor Elora Mukherjee of Columbia Law School. Coming up next on the Bloomberg Law Show, President Trump's pick to sit on the Third Circuit Court of Appeals gets a heated confirmation hearing. I'm June Grasso, and you're listening to Bloomberg. President Trump's pick for a New Jersey-based seat on the U.S. Court of Appeals for the Third Circuit is his former criminal defense lawyer, Emil Bove, a former federal prosecutor in the Southern District of New York. He was on Trump's legal team during his New York hush money trial and defended Trump in the 2 federal criminal cases brought by the Justice Department. Bove now serves as Principal Associate Deputy Attorney in the Justice Department and has been at the forefront of some of the most contentious Justice Department actions since Trump's return to the White House, including the dismissal of the corruption case against New York City Mayor Eric Adams, ordering the firings of a group of prosecutors involved in the January 6th criminal cases, and accusing FBI officials of insubordination for refusing to hand over the names of agents who investigated the U.S. Capitol riot. Democrats on the Senate Judiciary Committee grilled Bove over those incidents, as well as a whistleblower's allegations that Bove had suggested at a March meeting that the government lawyers ignore court orders against the Trump administration's deportation policies. Here's Democratic Senator Adam Schiff of California questioning Bove.
In the complaint, it says Bove stated that DOJ would need to consider telling the court you and ignoring any such court order. Did you say anything of that kind in the meeting?
Senator, I have no recollection of saying anything of that kind. To the extent I
Wouldn't you recall, Mr. Bove, if you said or suggested during a meeting with Justice Department lawyers that maybe they should consider telling the court you? It seems to me that would be something you'd remember, unless that's the kind of thing you say frequently.
Well, I've certainly said things encouraging litigators at the department to fight hard for valid positions that we have to take in defense of our clients. I did not suggest that there would be any need to consider ignoring court orders. At the point of that meeting, there were no court orders to discuss.
Well, did you suggest telling the courts you in any manner?
I don't recall.
Joining me is Bloomberg Law Judiciary reporter Suzanne Monyak. Suzanne, it appears that this confirmation hearing got quite heated.
It was heated in some respects. The Judiciary Committee gets heated pretty often, so I can't say it's the most heated hearing I've seen. I think a lot of the grilling was what we more or less expected it to be. I mean, Emil Bove, really emerged as a pretty controversial candidate for this seat and someone that we've really seen Democrats rally against. And in recent weeks and months, we've seen quite a bit of reporting in the news. And by recently, just this week, a whistleblower making some pretty serious allegations against him. And so those were all things that we saw Democrats really press him on. But I, generally did see the nominee kind of kept his composure and did answer the questions, and in some instances didn't answer the questions. But most of the fire was coming from the side of the senators.
Tell us about the questions that related to the whistleblower and allegations that Bove suggested ignoring court orders.
Earlier this week, just one day before the hearing, we had a whistleblower complaint made public by a former Justice Department lawyer, been at the department for over a decade, Erez Raveni, who alleged that Emil Bove had, in a meeting in March, suggested that Justice Department lawyers actually ignore a court ruling against the administration's deportation policy if they were to receive one. That's a charge that Bove was asked about quite a few times during the hearings, and one that he pretty blatantly denied. He said that he has never advised a DOJ lawyer to violate a court order, and that what was said about him should not disqualify him for the judgeship. That's also been the statement we've gotten from other Justice Department officials when the whistleblower complaint was first made public, to say absolutely not, that didn't happen. But that was certainly a theme that we saw come up quite a few times during Democrats' questioning.
Bove is probably most well known as the Justice Department official who moved to dismiss the corruption charges against New York City Mayor Eric Adams, leading to mass resignations at the Justice Department. I take it there was a lot of questioning about that.
Absolutely. That initially was maybe one of the ways that he was most infamous on the Hill, was for his directive to dismiss corruption charges against the New York City mayor that led to resignations of high-profile prosecutors in New York and Washington, including the U.S. Attorney for the Southern District of New York, who, resigned rather than carry out that directive. That was obviously something that we saw Democrats press Bove about. And he, pretty much defended that decision and, felt that the dismissal was granted, so it must not have been, an extreme position. He denied the idea that it was political or any type of quid pro quo in any way. Democrats didn't seem convinced, but he did maintain that line of denial on that accusation.
If I remember correctly, the judge in that case, Dale Ho, was critical of the Justice Department, and contrary to the Justice Department's contention that there was no quid pro quo, said that everything in the case smacked of a bargain. Dismissal of the indictment in exchange for immigration policy concessions. I mean, he's done a lot in the Justice Department in the short time he's been there. Was he the one who decided to fire the prosecutors who worked on the Capitol riot cases?
Yes, that was yet another charge that we really saw brought up quite a bit by Democrats, was that he had really at the beginning of his tenure, while he was still serving as the acting Deputy Attorney General for the Justice Department at the second in command, he directed then D.C. Interim U.S. Attorney Ed Martin to fire a number of prosecutors who had worked on Capitol riot cases, the cases against participants in the January 6, 2021 riot at the U.S. Capitol during certification of that presidential election. Those have been prosecutors who had not been in office as long, which meant that they didn't have the same level of protections, and it was easier for them to be fired. But it was something that was really heavily criticized at the time by people who saw it as retribution against career lawyers who were doing what they had been asked to do. Again, Bove, denied that this was any type of political or retributive decision, and really maintained that it was more of a personnel decision. He brought up that the prosecutors had been, hired to be temporary and had been placed in a more permanent position by the Biden administration toward the end of their term, and that he didn't agree with that decision. So again, just really maintained his position that the decisions that he made that he was getting criticism for were not political.
What kind of questions did the Republican senators ask him, and did they try to sort of rehabilitate him?
I think as is typical during these hearings, you tend to get tougher questions from the opposing side than you do from the side that nominated him. We did get some interesting questions from Senator Josh Hawley, just on sort of how Bove would be as a judge and what his approach to judging would be, kind of separate from his past actions at the Justice Department. Bove said that he was a textualist, and that he would really consult the statutory statute, look at usages, try to look at the legislation at the time, and also indicated that he would be one to exercise restraint and avoid inserting himself, or declaring a definition of a law that was ambiguous, and would more prefer to defer back to Congress where language is ambiguous. So that kind of gave us a bit of a window on the more technical judging side of things, how at least he would see his own philosophy as a judge if he were to be confirmed.
I believe there's a 2-person Republican majority on this committee. Is there any indication that he won't get through this committee?
Not that I have heard so far, though, of course, I always say with politics, never say never. We have seen the occasional Trump nominee taken down. I think of Martin from the D.C. U.S. Attorney's Office that I mentioned earlier as an example. He lost the support of one Republican member on the Senate Judiciary Committee, and that was enough to tank his nomination. But of course, in this instance, the blue slip process whereby the majority party would consider the home state senator's consent and approval before moving forward a nominee is no longer in effect for circuit court picks. And Emil Bove, of course, is nominated for the U.S. Court of Appeals for the Third Circuit. So the opposition from the two Democrats, who are the two senators from New Jersey, is not a problem for his nomination to move forward. I did not hear any opposition from Senate Republicans from what I observed during that hearing, but we will have to see. I think at this point it seems that there are no obstacles, but of course he's facing a lot of opposition from Democrats and some ethics complaints. So we'll have to see how he moves forward.
And what can you tell us about those ethics complaints? He's
been subject to some ethics complaints, various complaints by mostly Democrats and other critics, including related to his conduct during the Eric Adams litigation.
Interesting that during his time as a federal prosecutor in New York, Bove was involved in several high-profile cases. But his actions apparently rankled some fellow prosecutors and defense attorneys. In 2018, the Federal Public Defender's Office compiled complaints about his behavior from defense attorneys and sent them to two top officials in the U.S. Attorney's Office. Yet about 18 months after the email was sent, Bove was promoted to be co-chief of the office's National Security and International Narcotics Unit. He certainly has an interesting history. Thanks so much, Suzanne. That's Suzanne Monyak, Bloomberg Law Judiciary reporter. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.